So, what am I about to say here? Oh, don't know why this is sitting there. Anyway, that's mostly what I want to say about express terms in a broad sense. I want to talk now about the parole evidence rule. I'm hoping I've cleared up the typos. I have this tendency to type parole with an E. We say the word the same way, the parole evidence rule, as when we talk about parole as in having a right to leave prison. I'm not even sure what the terms are. I just realised I took my shoes off and didn't put them on again. Probably would have got away with that if I hadn't said it out loud, right? Sorry about that. So yeah, if I'm going to apologise in advance if you see typos. Please point them out to me. I will clean them, all these slides up one day. Here we go. So what is the parole evidence rule? We started talking about it a little bit earlier. Parole evidence rule is the rule that the court, it's a rule of evidence around what evidence a court will hear in order to determine what the terms of a contract are. And it has two clear limbs, but essentially, I'm going to read here from the slide to make sure that I deal with all of it. If a contract is reduced to writing and appears on the face of it to be a complete contract, extrinsic evidence, so outside evidence, is not allowed, so the court won't hear additional evidence that varies, adds to, or contradicts the terms of the written document. So essentially what the court is saying, or what the law, or the rule, parole evidence rule is in working out what a contract is, if we've got something that looks and smells like a contract, and we don't have any reason to think that it's not a complete contract, then that's the evidence that we're going to look at in order to work out what the contract is. We don't listen to, we won't admit any extrinsic or additional evidence that adds to, varies, or contradicts. So it's sort of like playing cards in a sense. In theory, well, in practice, we can create a contract entirely verbally, partly in writing and partly verbally, or entirely in writing. Writing trumps verbal. So it's higher suite in our pack of cards, unless an exemption applies. Now, again, already you've probably noticed that I've oversimplified that. Writing trumps verbal if it appears on the face of the writing that the writing is the entire agreement. So if it doesn't, if it appears from the writing or from other evidence perhaps, that the agreement is partly in writing and partly verbal, then obviously the court will hear the partly verbal. But if the agreement by itself looks like it can stand, walk, talk alone as an agreement without anything else, you will need to be able to demonstrate to the court and bring evidence to the court to demonstrate that it was in fact partly in writing and partly verbal. So what's the rationale of this? It's to preserve the finality in written instruments that's meant to be final. It's recognising, it's an efficiency rule as much as anything else. It's recognising that in order for the courts to make sense of a contract dispute, it is sensible to rely on the written documents that were created at the time that the contract was made, or if it's a memorandum or note of the agreement made immediately afterwards. It's limiting the amount of information that the court has to limit also the extent to which you can have variation. Remembering, going right back to week one, topic one, where we're thinking about that question, what is a contract for? One of the key reasons, in my view, that we have contract law is to have consistency in commercial arrangements. And we're more likely to have consistency in, well, any arrangement really, but commercial arrangements in particular, if things are in writing. rather than relying on people's memory and their honesty as to their memories as well. So, what's the purpose of the rule? It promotes the finality of documents. It reduces the risk of perjury. If you can't testify as to what was said, then you can't tell lies about what was said. And it's there to facilitate efficient litigation. Oh, don't you hate it when I have really wordy slides? You like them when you're studying, I know, but not so much now. So this comes from Justice Kirby in B&B Constructions and Brian Cheeseman and Associates. If the written language of the agreement has a plain meaning, evidence will not be admissible to contradict that meaning. The purpose of the rule, which is of great antiquity in our legal system, is by no means irrational. It is to hold parties to bargains reduced to writing which are unambiguously expressed. So notice Kirby here is really pushing on the requirement for the writing to be clear. He's leaving open a door for extrinsic evidence to explain what the document means if it's not unambiguous. If the purpose of the language is clear, the duty of the court is to give effect to the intention of Parliament derived from unambiguous language. The social purpose secured by such rules is to discourage litigation with the time-consuming, costly and dilatory exploration of detailed facts and the resolution of conflicts of recollection and testimony. It is to add certainty by adherence to the effect of the clearly expressed written word. Again, the lovers amongst us, we want to have clear, consistent documentation. We want to make sure that all the essential terms are covered, that we've thought about the kinds of things that can go wrong and covered those off in the boilerplate terms where we need to, and that we use consistent, easy to read language the whole way through. But notwithstanding what Kirby says, in a commercial contract, it is certainly right that the court should know the commercial purpose of the contract, and this in turn presupposes knowledge of the genesis of the transaction, the background, the context, and the market in which the parties are operating. That from Lord Wilberforce. Justice Mason, our own Justice Mason, has also stated that the true rule is that evidence of surrounding circumstances is admissible to assist in the interpretation of the contract if the language is ambiguous or susceptible to more than one meaning. So we end up, even with something as clear as the parole evidence rule, with opportunities to think about when a court will look at other evidence, extrinsic evidence. So I mentioned before this idea of the rule having two limbs. So the first limb prevents the extrinsic evidence from being given to add to, vary, contradict the terms of a contract. And the second limits the evidence that can be given to explain the meaning of the terms of the contract. So we need to think about both of them. Just to make sure we're on the same page, extrinsic evidence is outside evidence. It might include oral statements, it might include other writing, it might include correspondence during negotiations, it might include evidence of other people's conduct, of relationships, a range of different things. It's anything that is not the contract document.